to say that they are waiting in the lobby to be admitted, but let's not wait any longer and start with our program. Okay, in our midst we have the Pillar 3, members. As we know that we have the National Strategic Plan is implementing right now, and one of the indicators of the plan is for the Department of Justice to develop regulations for the sexual offense or the management of the sexual offences court. And so it is an indicator that is sitting at Pillar 3. So we have here the members of the Pillar 3 of the NSP as well as our courts, the court officials, and different departments, and as well as the civil society that are also part of this process. So we have today as our panelists Mr. John Jeffery, who is the Deputy Minister for the Department of Justice and Constitutional Development. He has been quite instrumental in a number of pieces of legislation that have been passed on issues that relate to gender-based violence and femicide. And he has been with us in the department since 2013, so he's quite conversant with all these issues that we're going to be dealing with. And he has been instrumental in the amendments of the amendments, especially the recent amendments that we have had, which are for the, as we all know, that under Pillar 3 of the NSP, we have an indicator that talks to the amendment of certain pieces of legislation that relate to matters of gender-based violence and femicide. And there are 3 bills that are now currently being considered by Parliament. And one of those bills is the Criminal Law, Sexual Offences and Related Matters Amendment Act, Amendment Bill of 2020. And our speaker today has been one of the people who has been very instrumental in leading the process of the amendment of those of this legislation, so as to matrix and also to look into the issues of the National Register for Sex Offenders and other matters. And also now, as we know that, as I have already stated, that it is also an indicator in the NSP that we have regulations. And these are the regulations then that are replacing what we were calling the MATSO model for the sexual offences courts. So he's going to be talking about those regulations today and unpacking to us as what they entail and what are the changes that are bringing mostly to improve the services that our courts are offering survivors of sexual violence, and also, you know, covering also the improvements that are there. So with these regulations, these are the regulations that will be informing then what the actual makeup of what we are calling the section 55 capital A, sexual offences, which is something that he'll be talking about. So we would like then to welcome our Deputy Minister, and of course there is no one who is better able to speak on this, because he was also the person who was chairing the committee, the multi-sectoral committee that was putting together these regulations. And he chaired it from the beginning and up to an end. So we come then Mr. John Jeffery, is the Member of Parliament to speak on the regulations. Thank you, DM. We're giving you the platform.
Thanks very much, Praise, and good afternoon, everybody. Praise, how long am I meant to speak for? Praise, how long must I speak for?
Okay, we are giving you, it's a session of 2 hours, so we'll be giving you 40 minutes to speak on this, and then the rest of will be then the deliberations on the regulations. Thank you.
Okay, thanks very much, and I've put my camera on. I hope that doesn't cause network problems. Look, we started with the Sexual Offences Act in 2007. There wasn't really anything specific on sexual offences courts there, but I think that my recollection is that sexual offences courts, there were courts being dedicated to hearing sexual offences cases. They started going into disuse for a variety of reasons, one of which was I think some of the presiding officers were not keen to solely do sexual offences. The then Minister of Justice, who was Jeffery, set up a ministerial advisory team on the adjudication of sexual offences matters, and the aim of that was to look at re-establishing sexual offences courts. Now, from Parliament's side, there was an amendment, I think, which came in 2012 while this was being done, which provided, and that was you've heard about it as Section 55A, that the Minister can designate by notice in the Gazette a court as a sexual offences court. It doesn't have to be a regional court, it can also be a division of the High Court. So the history goes back to that, and regulations had to be made by the Minister under Section 67 of the Act, indicating the minimum requirements applicable in respect of the designation of a sexual offences court. So that's what went into the Act, and it was passed, and it became the Judicial Matters Second Amendment Act in 2013. It was assented to. The push on the designation and the regulations of the minimum standards were particularly from civil society, who were saying that the public needs to know what to expect, what they can expect from a sexual offences court if a court is a sexual offences court. Now, prior to that, the department was equipping courts with the equipment or the more specialist equipment to hear sexual offences cases, and was publishing lists of those courts. That was from the 2013-14 financial year, lists of those courts on the website. So if you go to the website of the department, you will see from 2013-14 right up until the current financial year, 2021, the courts having these facilities. but I'll go into the relationship shortly over that. Well, maybe not. Maybe just to raise it now. What now has to be done is that the minister must designate the courts that comply with the regulations. So you will not be having. You will only the Act only provides for one kind of sexual offences court, and that's a designated sexual offences court, designated by the minister. And there's no provisions for pure or hybrid. A sexual offences court must have a dedicated role, but it can hear other matters when it's not hearing when that sexual offences role is not in use. With the regulations, as Advocate Kambula has said, we set up a multi-sectoral team of the different role players, particularly the NPA, the Department of Justice, the South African Police, and then civil society organizations. And there were extensive engagements in coming up with these minimum requirements. That was actually done before the last elections. They were sent off to the Chief Justice as to give him an opportunity to make input. It seemed there were some administrative problems there, but eventually, and that was after the elections, the Chief Justice agreed with them, and Section 55A and the regulations came into effect, I think, with effect from the regulations were approved by the minister and were published on the 7th of February and came into operation on that date. And the president determined the 31st of January this year as well as the date on which the Judicial Matters Act, those sections of the Judicial Matters Act came into operation. So where we are at the moment then, and Advocate Kambula can explain it if necessary, a process of checking on the courts that have the facilities to ensure that they do comply and can therefore be designated as sexual offences courts by the minister. Really, just in short, the regulation set out a catalogue of support services and resources that must constitute a sexual offences court. The services include court support, court preparation, emotional containment, trauma debriefing, counselling, private testifying service, intermediary service, and information services. And then there's also, the regulations also provide special services for disabled survivors of sexual offences, and in addition, infrastructural capacity. So basically, just briefly going through the regulation, Section 3 or Regulation 3 sets out broadly the requirements, and that is that a sexual offences court must provide the facilities in Chapter 3. That's the facilities, have the devices and equipment referred to in Chapter 4, render the services referred to in Chapter 5 of the regulations, and proceed with the requirements set out in Chapter 6. So it's basically facilities, devices or equipment, and services. So the facilities are basically a waiting room for complainants as provided for in Regulation 8, a testifying room as provided for in Regulation 9, a court preparation room as provided for in Regulation 10, and a consultation room for the prosecutor to consult with the complainant as provided for in Regulation 10 as well. Just sorry, can you hear me all right? I'm saying that the quality of the sound is not good. Can you hear me all right?
We can hear, but I think that the sound is not a brilliant sound that one will be expecting. I'm not sure as to whether you can come forward to the camera, I mean to the speaker.
Yeah, I'm trying to do that.
Yeah,
Is
much
that better?
better now.
I did
It's
realize
much
I had
better.
my notes on
Yeah.
the laptop, so maybe I was covering the microphone, and my apologies for that. Okay, so I've talked about the facilities. It's also important to highlight these facilities must be child friendly and accessible to persons with disabilities, to accommodate their assistive devices, and must also accommodate the needs of older persons. There's also provision for guide dogs must be allowed in. The court preparation officer or victim assistance officer, the court manager or suitable official designated by the court manager must accompany the complainant to and from any of the facilities, the courtroom and the restroom, when they need to. So they need to have a person there to accompany them. The waiting room must be furnished. The waiting room must be furnished so that it's accessible to adults and persons with disabilities. It must take into account the different ages of the complainants who may be using the facility. So in other words, children and adults. The testifying room must be conducive to the proceedings, have a layout that facilitates the enhancement of the quality of evidence and sets the complainants and witnesses at ease. And it must be furnished in such a way that it mustn't distract the witness. And then the testifying room must have the devices and equipment contemplated in sections 158 and 170A, capital A3C of the Criminal Procedure Act. There must also be a set of anatomical dolls, and a set consists of, I think it's 6 dolls, a male child, a female child, a male adult, a female adult, an aged male, and an aged female. And the prosecutor and an intermediary can only use these dolls if they've received training in the use of such dolls. There must be a court preparation program. Sorry, there's somebody who keeps trying to get into the Mackenzie Tsimane can't get in. I don't know if the controllers can let them in. There must be a court preparation program developed by the NPA. That's also Albertina Mashilane. She can't see or hear. Anyway, I presume everybody else is looking at those, or the relevant people are looking at those messages. So sorry, I was talking about the court preparation program, which is developed by the National Prosecuting Authority. It's accredited with the Health and Welfare Sector Education Training Authority, CETA, and it's aimed at familiarizing complainants and witnesses in cases with the court environment, with a view to preparing them to testify and to provide assistance and support to them. And all persons involved in the criminal justice system must be made aware of the preparation program. The needs of a complainant must be identified by the court preparation officer or the victim assistance officer after the program has been conducted, and they need to inform the prosecutor, the intermediary, or the court manager of the needs. There's also a requirement of trauma debriefing for people involved in the case, the magistrate, prosecutors, court preparation officers, and court officials. Now, as far as intermediaries, there needs to be a pool of intermediaries available who can provide the intermediary services at the designated court. The intermediary must be mindful of the limitations and capacity of a complainant or a witness giving evidence with regard to his or her form of vulnerability, age, physical and mental status, and stage of development. And the intermediary must request a court for a recess if it appears to him or her that a complainant or a witness who is giving evidence is fatigued or distressed. The regulations also recognize the importance of court supporters. If there's a sign language interpreter, due regard must be had to the physical fatigue that may result when he or she is interpreting. The designated court must ensure that sexual offences cases are finalised expeditiously and delays are avoided as soon as possible. The regulations place a duty on court officials to be sensitive and to make the court as user-friendly as possible. And there's also a directive that court officials, when interacting with a complainant or witness, must use a simple vocabulary and avoid technical terms as much as possible. So those are really all the requirements in the regulations. There is a National Court Support Services Committee, or NCSSC, which the department established to establish a victim-centric criminal justice system, which has representation of, amongst others, the Department of Justice, the NPA, the police, social development, and Department of Correctional Services. And they have been, in the last financial year, monitoring progress in the implementation of trauma debriefing programs for frontline officials. And they've introduced training on the information management tool and the diary system for intermediary services, and the proposed amendment of 170A of the Criminal Procedure Act to extend intermediary services, and initiated a process of standardizing the specifications of the anatomical dolls. So, Advocate Kambule, I don't know if you, how much further you want me to go. I think the regulations are pretty self-evident. As I said, what then has to happen is that the existing sexual offences courts, or the courts with sexual offences equipment, need to be assessed to see that they comply with these requirements. These requirements, basically, the regulations do largely follow the MATSO requirements. If anything, I think they are slightly less onerous than the MATSO requirements. So there really is no reason why every court can't be designated as can't be a designated sexual offences court. I think the area that one has to, though, also look at is that in some places, and I'm thinking particularly of KwaZulu-Natal, Umlazi and Ntuzuma or Kwamashu, which are courts covering big areas.
Receive a different amount for doing exactly the same.
Sorry, whoever's talking, can you mute, please?
May I ask that we all mute? Thank you. Sorry, DM, you may proceed.
Thanks. Thanks. What I was just saying is in KZN there are, I mean, if you take Umlazi and Ntuzuma, there are meant to be 2 sexual offences courts. And there are 2 courtrooms with the facilities. But effectively, they are not using them because of saying there are insufficient cases. This is whilst the number of cases reported at the police station are increasing. And I think that's of concern, because we need to be getting to a situation, I think it's already in some or other provisions, that, cases must start, I think, within 9 months. So it is important for the victims or survivors of sexual offences that the cases do start as soon as possible, so that they can get the issue, get through the issue, get over the issue, and not have to testify after a number of years. I remember going to the Madadeni Sexual Offences Court or the Madadeni Regional Court in KwaZulu-Natal and the Madadeni Tutuzela Care Center, and none of the people at the TCC were testifying in court because all the cases that the court was hearing were cases that had taken place before they actually started working at the TCC. And in fact, it was, I think, a 3-year backlog. There was no case that was younger than 3 years. So those are all aspects that need to be looked at. So yeah, Advocate Kampula, I don't think there's much else I can say at this stage. I haven't taken the 40 minutes, but maybe then to respond to questions and to inputs. Thanks.
Thank you, DM, for that information. You have actually unpacked what the regulations are all about. As you know that colleagues and all the guests that are in this platform, that are on this platform, that when we are talking about the sexual offences courts model, it's a homegrown model. Other countries have learned from South Africa and adopted this model, so it is ours. So it is our pride as a country, and we have the responsibility, therefore, of supporting it and ensuring that we are improving it as we move along. So what the Deputy Minister then has shared with us is that being in this homegrown model, now Parliament and the Minister as well has approved the regulations. So, and this is what then he was unpacking then what builds the regulations and this catalog of support services that is embedded in these regulations. So now, as he have already also indicated that it is stakeholder inclusive. So now the court supporters that will be drawn from the civil society. The regulations recognize their role in terms of supporting victims as they engage with our courts, and the role of the social development of SAPS, of the different stakeholders, the NPA, court preparation officers, intermediaries, and so all of those people, I believe they are here. So now we are giving you the platform of asking questions of clarity, because now they have been approved, as the DM has said, in February. So now the ball is in our court as the implementers. Parliamentarians have done their work, the politicians have done their work. So now it is us. They've responded to the call that we were making as we were marching the summit and saying that we want to have a statutory sexual offences court. So now they are not only statutory sexual offences courts that we have, and we also have now the regulations that are actually giving us unpacking as to what should be making these courts. So this is what he has said. So now I'm giving it to people on this platform to ask questions as to what is it that you are expected, because now, as I have said, that we have this responsibility now of implementing these regulations. They are not only talking to the Department of Justice, they are also including other stakeholders. And even if you are not a stakeholder there, it's your responsibility to ensure that we have a country that is a criminal justice system that is victim-centric. And there's one more thing that I think that we also need to know, especially us here as Pillar 3 as stakeholders, is that the regulations, as he is here now, the Deputy Minister is here to say that we have complied. We have approved develop the regulations and approve them. And now it is time for the implementation. And also these regulations are also compliant with Article 1 of the Presidential Summit Declaration, which we all participated in the development of the document, which requires that everyone must take responsibility of ending a GBVF in the country, and are also, responsive to Article 9. I think it's Article 9, which says that which requires, if it's not 9, it's 13, that requires that we have a criminal justice system that is victim-centric. So he has enumerated a number of support services that form a basket of services that should be provided to the survivors as they enter in the criminal justice system. So now you can put your questions on the meeting chat, but then I will also request those who would like then to ask oral questions. Any clarity, any comment that you have, any input that you would like to give, we're giving you that platform. It's over.
Advocate Kambula, maybe while we're waiting, just to emphasize that the purpose of the regulation, well, any court can, regional court or high court can hear a sexual offences case. Some courts do have some of the equipment that a sexual offences court has. So, for example, they might have a separate room for witnesses to testify in, but they might not have any of the other requirements. What the regulations are doing is to set the minimum standards for the designated sexual offences courts, because, as I said, the call from particularly civil society was for the public to know, for everybody to know what is the minimum thing that can be, services that can be expected at a sexual offences court. There is a provision, and as I said, it's the court must provide the facilities in Chapter 3, have the devices and equipment, render the services, and proceed in accordance with the requirements of Chapter 6. I hadn't mentioned the subclause after that, which is that regulation setting out all the requirements doesn't preclude a designated court from dealing with a sexual offences case if, after its designation, it does not comply with any of the requirements set out in Subregulation 1, pending the outcome of steps taken. The reason for putting that in was so that you didn't have a situation where an accused would try and argue that this is not a designated sexual offences court anymore, because instead of 8 anatomical dolls, 1 or 2 are missing, and therefore the trial that was carried out was not in accordance with the regulations. So nobody is going to be able to escape accountability through that. There are also then provisions for processes, complaints, that kind of thing to be followed. I see that, Jean has asked 2 questions that she knows the answer to, but I presume she's asking so that others, and that is what's happening now with the sexual offences courts, what's the next step? It's the same question twice. And as I'd said, the regulations have been gazetted. Section 55A is in effect. The minister now has to designate the sexual offences courts, and they will be the sexual offences courts in South Africa. And they will be the courts that the so there is a process of assessing the courts. I think it's about 106 of them that have the facilities. A process of assessing whether they meet the requirements of the regulations, and that is being conducted. I think Advocate Kambula can speak more on the process. There is a checklist, although the checklist has more than the regulations actually have. So the guide dog, the courts must allow a guide dog in if necessary. The checklist wants to know if that guide dog will have a water bowl. There's provision for fresh water for witnesses in the waiting room. I'm not sure if bottled water is fresh water, but I would have thought bottled water is sufficient. But anyway, that is Advocate Kambula can speak on that and the process. I think it's envisaged that hopefully by the end of the month, that the minister can designate, or at least during the 16-day period. Thanks.
DM. Thanks for the further explanation. Colleagues, you can use the meeting chat to communicate your question, and you can also raise your hand so that we have we give you an opportunity of giving an oral question. So we welcome that as well. So there's another question that is coming from Dr. Linda Naidu at DM. He says that many children present with special needs. Is there a repository of resource persons that can be accessed to meet their needs? Before DM can respond to this question, I would like just to say that there are many areas. There are many services that he has said that they form part of the regulations. So this is the platform then to say that are there any areas of consideration that you are saying to the department and also the other stakeholders that are responsible for the implementation of the regulations, that are there any questions that you need to know, like with the court supporters, what are they expected to do, and the intermediaries, are there any changes? So it's a number of support services that he has mentioned. So we are asking then that you raise your question. So I would ask you right now, DM, to respond to Dr. Linda Naidu of UN, and is asking as to how many children are present with special needs. Is there a repository of resource persons that can be accessed to meet their needs when presenting their evidence in court? I think that she has heard you talking about the AD dolls, the anatomically directed dolls. Over to you, DM.
Thanks, Advocate Kambula. Look, I mean, the question is relating to the presentation of evidence of children with special needs, and what is envisaged in the Sexual Offences Act is for intermediaries to assist. Currently, it is children, people with disabilities who get assisted by intermediaries. In terms of the legislation in Parliament, it will go wider to adult people as well who are needing support. There's a section on the intermediary services. There's reference in Regulation 18 to the senior official in charge of the intermediaries must ensure that there's a pool of intermediaries available who can be appointed. I think, though, that and the senior official must take the necessary steps to recruit intermediaries appointed on an ad hoc basis if there are not sufficient intermediaries to be employed at the court. I would imagine that an intermediary for a special needs child probably is quite a specialist skill, and I think it would be important that a database of such people be developed who can be, if necessary, appointed on an ad hoc basis. I'm now not talking about your normal intermediary who would have the skills to be able to assist a child present evidence. But this is now, you're speaking about a special needs child. There may be specialist skill that's needed there, and it, I'm sure, would be useful if provinces, regional offices can develop databases of those people so that they can be called upon where necessary. Thanks.
Okay, thank you, DM. There's another question that is coming from Madame Mandisa, is asking, can we get the time frame of Khayelitsha Court infrastructure? We noticed that there is not much done since the regulations were gazetted. I'm so happy that this question is not coming to me, DM.
Well, I'm going to direct it to you, Praise. I mean, look, I just don't know with Khayelitsha. I mean, I've been there, I think, twice to receive the memorandum wanting it to be a sexual offences court, and I think last year I wasn't able to make it, and Richard Jantjies, a member of Parliament on the Justice Committee, received the memorandum. I'm not sure what is still outstanding and what we still need. When I was there was a problem last, which was, I think, over a year ago. There was a problem over the separate entrances, which are actually not a requirement in terms of the regulations. A separate entrance for the victim, but even though it's not a requirement, provision can be made for the survivor to come in separately. There's another gate there. Then I think there were problems over the witness, the survivor, possibly mixing or coming into contact with the accused. But I thought that could also be resolved. So it's a pity that Advocate Hisham Mohammed was working on this until he left the department. I guess Khayelitsha needs a sexual offences court, but I don't honestly understand why it's taking so long to resolve this. I guess what we can do is then be able to check what are the outstanding items that are not there that should be there, and then move forward. So Mandisa, good question, embarrassing question that it hasn't been resolved yet. All of us here from the department, so that includes the convener, Advocate Kambula, we need to ensure that Khayelitsha can get made a sexual offences court. I just see other people here, Advocate Africa, please assist as well.
Yeah.
You're from the Western Cape. But this can't keep going on. Thanks.
Okay. We're going to be giving you, Lizelle, if you can take the platform, and then after that I'm going to be responding to this question. Thank
Sure,
you, Lizelle.
Sure. Thank you, Praise. Good afternoon, DM and colleagues. Praise, I'm hoping that your information is the same as mine. I just spoke to the representative at the regional office because I saw the question coming through from Mandisa, and I just wanted to find out from her what the position is. What the challenges were previously, and I think it was probably the last visit the DM had, apart from the issues with regards to the entrance, there were also challenges with regards to the ablution facilities. But it was functioning as a sexual offences court. TV screens, the CCTV equipment, all of that had just been replaced last week, but there was a subsequent break-in. So now that has also set the court back with regards to being able to deliver those services immediately. So we are following up with the regional office to be able to rectify that situation, but it was rectified. And then obviously because of the break-in that had occurred, I think 2 or 3 days after the CCTV equipment was actually put in by national office, it was actually stolen. So that set us back a bit there, and we were being kept informed by regional office. Apart from that, what I have been informed by the person responsible for equipping Khayelitsha from the regional office is that they have received quotations for a mobile unit, and Department of Justice is responsible for providing that mobile unit. So they have received quotations. What they are waiting for at this stage is the approval from the Department of Public Works as well as municipal approval before we can actually sort of place the park at the court. But that's as far as the information that I have presently. I'm not sure if you have other further information, Praise, but it's not that nothing is happening. It is being happened, but obviously the wheels within government does turn a bit slower than what one would expect. So that's all I can offer at this stage, DM.
All right. Thanks, Lizelle. I think that you have actually covered what I was going to say. Now, I would like us then to give an opportunity. I will start with NPA. Is there any contribution that you would like to make in terms of the presentation that is done?
Praise, sorry, just before that, Mandisa's come back to say we were promised the retrofitted container a year ago. That's the one that Lizelle spoke about, and she spoke about I think Public Works as needing to give approval in the municipality. Look, where I am, I fully appreciate whatever that Khayelitsha must be a sexual offences court. I'm embarrassed that it's not. I'm tired of receiving memoranda from civil society. Sorry, civil society. But you're right to raise the problems. The problem is I don't necessarily get told that there's this or that problem that has happened. So please, Lizelle, the regional office isn't here, I think, but where there are blockages, please tell me so I can assist with taking them up. I really don't want to have to receive another memo. It comes during the 16 days, so it'll be coming in the next month. From civil society complaining about Khayelitsha. Tell me what is outstanding, and then I'll speak to Minister of Public Works if necessary, or the Cape Town Mayor or relevant people if necessary. I just wanted to add that. Thanks.
Okay. Thank you, DM. I think this is one issue that was, I know of the container that she's talking about, that it's a matter of the procurement and all those, but it's something that we'll make a follow-up on. May I then ask then anything that is coming from the NPA in terms of the implementation of the regulations? Is there anything that you would like, which is maybe of clarity from the NPA in terms of your role in the implementation of the regulations? Anyone from the NPA? I see that there's also PA here. Any clarity, any input? Yes, PA, we're giving you the platform.
Thank you, Praise, and thank you, Deputy Minister, for your comprehensive feedback in relation to the regulations. Appreciated. I think from the NPA, I mean, this is absolutely useful, Section 55A, and the regulations that accompanies it as well. and we are obviously ready to implement and take it forward. We've also amended the directives in line with the requirements of what the regulations stated, that places responsibilities on the prosecutors. In line with Section 66 of the relevant legislation, we're in the process of consulting with the relevant stakeholders in that regard. Once that is being done, we will then forward it via the necessary format via the NDPP to the Deputy Minister and Minister and DG, and then ultimately to Parliament so that it can be gazetted accordingly. So for that reason, we're on track. We've also covered in our latest amendment to the training curriculum, we've included the regulations as they have been gazetted to inform prosecutors on the regulations and the status of that and the implications of the regulations on the prosecution. And we've also, in line with the NSP process, the National Strategic Plan on Gender-Based Violence and Femicide, indicated that apart from these designated courts, gender-based violence, in particular sexual offences, but the whole umbrella term of GBVF, should be receiving the priority focus in all DPP offices, which we've been confirmed by the DPPs that that is indeed the case in taking it forward. I think from us, from the NPA, that is crucial. Then lastly, obviously, because of the relevance of stakeholder cooperation, the regulations places responsibilities on many of us. But ultimately, the success of making this a workable model, as Praise said earlier on, the homegrown model, as she referred to it, will obviously only depend on us working together as a united team to make ultimately those in ways and ensure that service delivery will ultimately be improved for the victims of these unfortunate offences. Thank you. I'm covered. Thank you, Praise. Praise, I'm covered. Thank you.
Thank you. Oh, I was talking here. And so, yes, thank you, Pierre. Thank you, Pierre, for your input. And now we would like them to get, because we have people from Verulam, from Pinetown, from Limpopo, coming from the different courts. Is there any input that we can get from the judiciary now in terms of the implementation of the regulations? Is there anything that you would say that if we can, when we are implementing this regulation, these are the things that we need to consider? There was also somebody before we came in who was saying that we need to ensure that they are language accessible. So what it means is that we need to translate them into different languages and simplify them, and so that people are able to understand. So that's one thing that I also received before this. So we need those inputs. So now I'm asking then the judiciary, who's going to be speaking on behalf of the judiciary, in terms of what is it that needs to, as Pierre has said, that the success of the implementation of this regulation rests on us, all of us, particularly the members of the Pillar 3, NSP Pillar 3. Right? Anyone from the judiciary? I know I've seen a number of you who are here. Is it because today we have a politician that everyone is quiet? DM, are you freezing people? Your presence is freezing people.
I want to hear from them. So.
Okay. So now, Yaki, we're giving you a platform, Ms. Vessel. What is happening today? People are so quiet. Eh?
Thank you very much. I totally agree with what Pierre was saying. In the end of the day, the success of the court depends on how well everybody can work together and ensure that everything is being arranged and done the way it should be. Now, one of the things that is in the regulations is that there's a lot of specific obligations put on the court managers. So maybe the question would be whether or not there will be any kind of specific training or instructions or circulars in this regard for court managers to make them aware of the responsibilities placed on them. And then we have been having a continuous problem with the slow turnaround time to get CCTVs and CRT machines that is broken fixed, and whether or not there's anything that can be done to deal with that, because without a working CRT machine or a working CCTV machine system, we are not able to have the witnesses testify, and the cases can't move forward. That's from me.
Okay. Thanks, Yaki, for the input. You have mentioned the issue of training and also a Justice College. I think that I'm not sure whether Justice College is represented here, but then they are in a process. They're in one of the task teams that we have. They're in a process of developing the learning material from the regulations. So it's to train people on the regulations. And also the issue of the CCTVs and all that is something that we need to come up with a mechanism of ensuring that the speedy repairs of these systems. It's only just that the department is dependent on service providers to deliver on these services. So it's one issue of concern that needs to be dealt with. So now I will ask then the civil society, is there anyone who would like to make an input as part of the Pillar 3, NP, NSP Pillar 3?
Thanks, Advocate Kabula. I haven't seen a lot of my colleagues attending, unfortunately. As you know, there were quite a few connection and technical issues. But I think from civil society, we are really positive about the regulations. You will know that this is something that has been on our agenda for a long time, and not only Rape Crisis, but also other civil society organizations are really excited about the fact that there is a legislative structure for these courts now, and obviously that civil society's role is recognized in, for instance, providing court support. I think our question, and I'm very glad that Ms. Wessels asked the question about the training of magistrates, but really is about how do we make sure that all the people who work in a sexual offences court, from the intermediaries right up to the magistrate, that everyone is trained to ensure that the victim survivor receives the least amount of possible secondary trauma. I think that's a really important question for us. And then obviously making sure that different stakeholders, I mean, I'm not only talking about the sexual offences courts, but also the forensic units linked to them, civil society organizations who work in the courts providing court supporters, that all the stakeholders can continue to work together in a coordinated manner to ensure that when there are issues at a particular sexual offences court, that's addressed as soon as possible. So the one question is about the training of court officials generally, and the other is about coordination structures within the courts to make sure that issues are addressed as they arise.
Okay, thank you, Joan. I have just a follow-up question on that one. What is it that we would like to see being incorporated in this learning material, the training? Because we have a section 66 that requires a number of stakeholders to put together their courses.
Sorry, Advocate Camilla, I'm losing the audio.
Yeah, Praise, we've lost you. Praise, are you there? Otherwise, you'd need to. Your mic is off, but we can't hear anything.
Can you hear me now?
Yes, now we can hear you.
Okay. You can hear me now. All right. So I was asking that as we are talking about the training, it's one issue that many people have been saying that we don't have the adequate skills to respond to the cases of sexual offences, and we don't have the sensitivity, the adequate sensitivity of dealing with these cases in terms of the special needs that the victims would have when they enter into the criminal justice system. So now I'm asking, as you have raised the issue of what to be built into training courses, as you know that even the regulations, they are also the same team must also be trained, and everybody who is going to be dealing with matters of sexual offences must be trained. So where material stakeholders not to deliver as expected in terms of the skills. So I'm asking that question. Is there anyone who can take it? It's not it only to Joan.
Sure, I'll give a couple of seconds to see if anyone raises their hand. Or Lizelle from the NPA says social context training as a start. I don't see anyone else raising their hands or issues coming through in the chat, except that Ms. Vessels agrees. Yeah. But I think it really is about providing training that isn't only a tick box exercise, right? A 2 or 3 hour social context training or gender awareness training, but something that has really been tailor-made to firstly the audience who hears it, and secondly by experienced facilitators who have special skills and expertise to present this kind of training. And so I realize that that's quite a big ask, but I think if we really want to have justice officials who can manage to make survivors feel safe and supported when they have to enter the court system, we have to invest in long-term.
Okay, sorry, Joan. There is somebody who is talking in the background, so it's sort of we are unable to get what we're saying. I'm requesting everyone to mute yourself, so that we are able to get the. Joan, if you can carry on. Sorry for that.
Sorry, Advocate. I'll type a quick summary in the chat.
I think that I'm trying to get. There is also another input that says that it's social context. So I think that we really need to, because you will find that every stakeholder says that I deliver training on social context. We need to unpack, the content of the social context training that is being delivered? Is it a training that is succeeding to change the mindsets of people? And also, is it a training that addresses all the needs, the fears that the victims have when we really need to look at as you know, us here as Pillar 3 stakeholders. That's one area that we need to look at, because you find that everybody says that I'm delivering training on so, but why is it failing then to change the attitudes of people? So there is also another, I think this one is coming from John as we are drawing to an end. He says that all trainings should be delivered by trained and specialized facilitators. We cannot only deliver tick box trainings, but it must be long-term transformational training to ensure that survivors receive the just support they deserve. So it's another thing that we really need to look at, you know, that because we say that we have trained people and you find that it's a one-day training. It's 2 days training, and so we need, those are the issues that we, what is it, what it takes to change an attitude of a person. Those are the issues that I think that we need to look at as Pillar 3. So I think that at some point, because we do have an indicator 3 that speaks to training, so we need then to look at how do we deal and look at all the training, and if it takes us to considering the training modules that the different stakeholders have developed for sexual services, it's something that we need to do as the members of Pillar 3. So now, without any other questions, I would like us then to close this session, but I will give then the Deputy Minister the last opportunity of closure. There is also another one, it is coming from Yaki, and she's saying that the regulations require that ad hoc databases be established. Let me just check and finish it. Okay. Okay, I'm trying to get to the end. Our regulations require that ad hoc databases be established for intermediaries. Have such databases established yet in all provinces with the ad hoc intermediaries to receive any do ad hoc intermediaries receive any kind of training? Okay, so it's like a twofold a question. I'm not sure whether DM would like to take this one or would like me to take it, because it's a question that talks to the intermediaries. But yeah, before I can give it to DM, okay, let me just say that it's one of the indicators that we have as in the 100 days rapid results plan, that the department must put together that database. There's a process that has started. We have found that in our the ICM system, that is the integrated case management system that collects data on services, on the intermediary services, that our figures do not tally with the ad hoc intermediaries that are registered with the courts. So we are trying then to reconcile those figures. And then you have also raised an issue, and that's an exercise that will be finalized before the end of this month, because the rapid results, the 100 days rapid results ends at the end of this month. So the other thing that we have raised is the issue of training. You know, it's one area that I think that we need to look into, because Justice College right now is in a process. This is what they have reported, that they have produced a draft learning material for intermediaries. And so we are still looking at them finalizing that process so that we can have a fully fledged learning material that is for the intermediaries. And also, a person who's coming into the system as an ad hoc intermediary, I do agree that needs to be taken through, the process of training. So it's something that I think that I have noted it down that needs to be dealt with. Yeah, I think that is that. And also, I would like to say that there's what we are calling the intermediary system. It's an electronic system that is assisting. It helps the prosecutors. It's a communication between the prosecutor and the court manager and the intermediaries, so as to ensure that there are no cases that get postponed because of the intermediaries. As you know that, and now we have lost a number of intermediaries from the system, and the government purse is gone leaner and leaner as time goes on. So the system then is encouraging and facilitating that throughout the country, then we are able to share the resources of intermediaries. So if there is an intermediary that is needed in Limpopo that speaks Afrikaans, so another province should be able then to provide and to ensure also the in the courts that are in the neighboring jurisdictions that are able to share the resources of intermediaries. So it's meant to do that. So it's just of ensuring that we are able then to cover the resource gaps that we're experiencing at a number of courts. I think that is that. I don't know, DM would like to add, but I will, as we're drawing to an end, to give an opportunity our panelists to say the last word on the presentation that he has given us. It's over to you, DM.
Thanks, Advocate Kambula, and thanks to everybody for the questions and the participation. Maybe just to highlight, well, the main point I'd want to make is that, yes, training is important, but what is also important is the mindset, and that is a mindset to ensure that the victims, the survivors of sexual offences get justice. And that's something we need to inculcate in all people working, in particular in the sexual offences courts. There also need to be consequences for those who are not doing what they're meant to be doing. So, for example, there is provision, it's Regulation 13 relating to the electronic devices operating in the court, that the sort of ultimately responsible for these devices or equipment in the testifying room or the courtroom not functioning properly, and that he or she must immediately inform the relevant regional court president, if it's a regional court, of the steps to be taken to solve the problem. I think it's important to note that section was not popular with some sections of the department, but it went in, it stayed in, it's still there. And it's to try and ensure that there is accountability. These days of things being reported and nothing gets done, they can't continue. We have reduced the turnaround time in terms of the replacing of equipment, the CRT equipment, in terms of a service level agreement with Datacentrics who run that equipment. But we need to ensure that there's comeback. There are consequences. Another area just to highlight is the issue of court supporters, and that's basically the civil society organizations. And the requirements basically are employment by a non-profit organization. It must be registered in terms of the Non-Profit Organizations Act, and it must be accountable to the provincial and local departments of social development, and I'm not sure if that's provincial or local. It should be all, but anyway, I think. But the issue there was that there was a whole lot of debate around, does it need to be funded by social development? And the view was that that's not important, but they're not a loose cannon. They need to account to social development as to what they're doing. But we also need to be cognizant of the fact that in most of the sexual offences courts, there are no court supporters, unfortunately. So we also need to ensure that the system can also work where all the services have to be provided for by the state. But Advocate Kambula, you know, we need to move quickly to the designation of the sexual offences courts by the minister, and then we need to ensure that they function optimally. The real purpose of having these sexual offences courts is to make a difference in the lives of the victims, survivors who have to testify against sexual offences or against a sexual offence offender, and that's the real test. Thanks very much.
Him to come and address us as the NSP Pillar 3 team or committee. We have received the presentation, and also as you have now presented, you have actually officially handed the document to us, because it falls under us in terms of implementation. So your presentation today has officially handed it to us as this team to ensure that we implement it to the fullest and effectively and efficiently, to ensure that it responds and it achieves the goals that it has been intended to. It has been intended for. So we are receiving the document then as Pillar 3 team, and we are promising then to implement it as you have requested, as we have heard from the members that there was an emphasis on us holding hands together and taking responsibility and take the multi-sectoral approach to the implementation of these regulations. So we are taking that responsibility, and we will be coming back then to say that this is what has been done, and we are moving with speed to ensure that there is also the designation of these courts and the full compliance with the regulations. And I would like then to the members to say that as you know that we have one of the activities which is to finalize to develop the sexual offences courts designation compact, and we said that we will be, as we have the task team that we have established that is responsible for the development of that compact, that it will be taken to a bigger forum. So we requested then that our deputy minister, as the one who has been pioneering this process, to chair then the bigger forum that will be looking into the adoption of the compact, So we are then DM promising that we will be coming to you then with a date for you then to chair that forum that will be adopting the compact for implementation, looking into everything that we are set to do. So I think now if there are no other questions as from the chat, so we might just close the session. Is there anything that one would like to say before we can close the session? So what we are saying is our way forward is that we're finalizing the compact, and we will then be taking it to a platform for multi-sectoral adoption. No inputs. So without any inputs, then thank you so much, colleagues. Thank you so much, Pillar 3 members, for handling this session, and also for taking the responsibility of ensuring that we achieve all the indicators that are set for us. And we're also thanking DM once for us and officially this so that we begin to implement it. So thank you so much, colleagues. So now I will declare the session. Thank you. Now the platform. Thank you.
Thanks, Advocate Kambula, and thanks everybody.